NSC also. It's about the regional tribunals. In the lead up to the 2024 manifesto, no, NDC promises on back to the regional tribunals. When you read from Article 144, and not TV3, Kpebu, Martin, Kpebu, Kwasi, Kwarteng, Kofi Bentil, and Akwatia MP, a lot of interesting perspective. Now, and conversation is more law. Because my friend lawyers no be the version of what they think the tribunal should be. And for the first time, Kpebu agreeing with NPP on a matter. That should tell you something. It's a very interesting. I'll share with you something this week. A court of kind of appeals called the Court of Appeal. Efia Sewa Sariboche. Her leadership, Yanene Kasai, and I'm asking the question about Article 144, the appointment of Supreme Court. He says something that is very instructive, and I'll link it to the analysis for you today. And then more of analysis on my part. I just want you to do an analysis, what to make of it, common sense analysis of it, because the tribunals largely is a court for the people. When you read Article 140, especially the 147, talking about the regional tribunals, and I'm you could see with TV3 a lot of interesting perspective. Mashada will be 5 minutes, remarkable at the abroad. So best subscriber, most subscriber no click the notification. The video be a tuma, and I'm the video be a tuma be hunu etimashe. We are. You will certainly have a comment. Feel free, leave that comment in the comment section. We are measure so we could GoldBerry Construction Limited. Do that episodes in assassin kratas the documentations related to your housing GoldBerry. Anybody sage money na at the amount we are. Or addition later to Chama later to agent care covering Pomo Beshow, let me be a kama at the amount. Now, and run you could see with TV3 very interesting perspective. Let me mark Kwasi Kwarteng the affair. So, Kasama NPP, this is what you have to say about the passing of the bill for the regional tribunals, and I said the tribunal system coming back into our court system. Your kind in
where is your nightmare really emanating from?
Alfred, you see this conversation. Let me take it from this angle. If I look at it critically, this bill solved the wrong problem.
The bill solved the wrong problem?
Yes.
What do you mean?
So it is not a question of whether or not Parliament can indeed establish such a bill. As for that, it is not in dispute. The Constitution gives that room. But the fundamental question is whether indeed we need such a bill or a law as at now in 2026, whether we need such a law. You see, I heard the arguments of the Attorney General and said they give meaning and effect and amplify certain provisions of the Constitution. But if that is the logic that he wants to advance, then there are certain provisions of the Constitution that also ought to have been given meaning even before now. We look at, for instance, Article 25 of the Constitution, which talks about the right to education, the fact that everybody shall have access to education and even education up to the tertiary level should some point be free. It's a fundamental human right. So if it is the state wants to give meaning to every other provision of the Constitution, then they should have given meaning to that one as well. And of course, you also look at the directive principles of state policy. Do you look at the educational objectives? You look at any other objectives. The state should have also given meaning as well. So it is not everything in the Constitution. The Constitution has always been a living document. You look at the mood of the nation, you look at the developmental objective of the country, then you align. You don't just say, I'm giving meaning or amplifying certain provisions of the Constitution, and on that matter, I am then going to institute or implement or establish the tribunals. You see, the point is that, Alfred, Ghana's justice system is not struggling because of the lack of the tribunals. Senior is a lawyer, Bentil is a lawyer, and of course, it appears almost everyone at least has an exposure with the legal system. The challenges within our legal system, it is not a creation or it is not a lack of the tribunal system. To the extent that if today you still introduce the tribunal system, the challenges within our justice delivery system will still not be removed. For instance, you look at the delays within our court structure and the delays within our judicial and the justice system. Is it a creature of the tribunal that is going to resolve it? Clearly no. I am a young lawyer, just 2 years at the bar. I go to court and basic applications and basic motions, you have to read them, then a typist sit there, type them. Sometimes you have to repeat yourself on 2 or 3 occasions. After about 30 minutes of moving your motion application, then another lawyer also writes and they type it. In 21st century, not just the lower courts, but I'm talking about the apex courts of Ghana. You look at the Supreme Court, you go there, people are sitting there and typing. You come to the Court of Appeal, people are sitting there and typing. You come to the higher courts, it's so normal. Yeah, whilst you speak. So everything you say, my name is Kwasi Kwarteng. So mostly you introduce yourself to the court. Kwasi Kwarteng. Probably I hold a brief of Kofi Bentil or Martin Kpebu. All these things, somebody has to type it. 21st century. How much does it take to procure technological devices to transcribe some of these processes? AI tools. The biggest and the most challenging problem within our judicial has to do with the trust and the confidence that Ghanaians place within the judicial system.
The trust and confidence.
Yeah, the trust and confidence.
I want you to hold on to that point because you talked about the mood of the nation.
Yes.
That, you know, the legal reforms.
Yes, exactly.
At some point, the mood of the nation demanded a fast-track high court.
Yeah.
Because people complained about the slow pace of the judicial system, and we got to accept the fact that the wheels of justice would have to grind so slow, but then the destination will still be achieved. Yeah, but then again, would you say that the mood of the nation does not demand the tribunal, as was the case with the fast-track high court?
I get what you're trying to do, but the difference is that such reforms were still on strengthening the existing court structures, not creating other institutions. You see, I do not have a problem when you strengthen the existing core structures. Like I indicated, the challenges within our justice system. You talk about infrastructure, justice, Alfred. There are courts that you go today that judges do not have chambers. There are courts that you go today that judges do not have accommodation. Yes, so they are supposed to come to work and act. There are places which ought to even get constant and sitting judges, and almost every time they are alternating judges. So for me, the solution to the problems or the challenges that confronts our justice delivery system is not the creation or establishment of these tribunals.
We na Martin Kpebu said there be NPP kano ebi en kore. Esa ban na careful na nso kan enie.
Where they have some basis to be the nightmares, right? Because in the past, during the PNDC administration, some of the tribunals had abuses. Being human institutions, I'm not justifying it, but I'm just trying to chronicle. Yes, it turned out some were corrupt, very corrupt, so and abuse people's rights here and there, right? So it's good that the minority is making that point forcefully, because that would then remind us to be careful in choosing the tribunal chairman and indeed the other panel members, because each tribunal shall have a chairman who is a lawyer and two other members who may not necessarily be lawyers. So what the minority is saying, and which I will join them in saying very loud, shouting from the rooftops, is about character. And character is a big problem. It's not only in Ghana, all over the world. It's a continuous debate. You have to keep reminding yourself, you have to keep making noise in order to be able to improve. So that one is well grounded. After your market didn't started, you remember the week before, Abu Jinapo made the same point on the floor of Parliament. Yeah. And yes, we lauded him here. That is good that we remind ourselves that we don't want those excesses, right? Yes, but where I depart from them is to say that because of those nightmares, etc., then we should not go ahead with the tribunal system. That argument, the logic of that argument is to say then that when Analyst did this expose and caught a lot of judges who were dismissed, then we should have shut down the judiciary. Yeah, that's the logic. Because the Analyst expose was bad, terribly bad. One judge, one goat. Those things. The judges who were caught taking goats, etc. You know, it was quite explosive, very extensive, even in fact, when it comes to the anecdotal evidence, when it comes to the higher courts, you know, it's well documented in the public, annals that for the sake of national security, they had to stop him from exposing the ones at the higher levels of the court, right? So what I'm saying is that, so that's a warning. So did anybody ever say that, oh, because of that, then we should shut down the court system? You say, so the argument serves a certain purpose, but there is a limit. There's a limit. Nothing stops us from starting afresh. As you've rightly shown, even apart from Article 125, 126, there's in 142 and then 143, etc.
142, 143 says a regional tribunal shall have jurisdiction to try such offences against the state and the public interest as Parliament may, by law, prescribe.
Yeah.
2 says a regional tribunal shall have such appellate jurisdiction relating to the matter described in clause 1 of this article as may be prescribed by law. Where exactly are you going with that?
Yeah, so that is it. So where I'm going with it is that it's a constitutional provision. Right. Or there are constitutional provisions on the public tribunal, and they have always been around. So we're just trying to revitalize. You see, revitalize. They went dormant, and so we are about to revitalize them and then move ahead. You say, so let's all put our hands on the wheel, right? Let's all join in to make it better. If we find out that it's not working, just as we stopped at a point, we will stop. We will stop. And we all know that even if it takes 40 years, one day Avenue Market and Co will be back in power. If they come and they are not happy, they can review it. But even before then, we ourselves here, me supporting it today, already I'll come to the point of the 42 days to finish a Galamsey case. Right. I think it's overly ambitious. Maybe that will be one of the first things will be. So the point is that we will begin to depart, we will begin to say the things we think will not work with the tribunal, and hopefully government may amend. If they don't amend, when Avenue Market and Co NPP is back, we will support them to review. You see, but for now, let's start. Let's start. The fact that even in our personal lives, we fail very often, and then they tell that when you forget up, most of us, when you fail, you start afresh. So it's the same in the public discourse.
We na Kofi Bentil say we enwu hia. Ghana ye problem ye won we nya regional tribunal here.
And you see me, my worries. We have been through this over and over and over and over and over again. Today you come and tell me that it's part of the constitution. It's part of the constitution. Look, it is part of the constitution that within a certain time we must make education free. Within a certain time we must create disabled access for all people. These are crucial things people need. And if you talk about disabled access, it is something we can do. We should have done by now. When you travel elsewhere, people are in motorized, wheelchairs in town because they are sidewalks. Today, you go to government buildings, there are no disabled access. Is this your priority? Is this your priority of all the things that we can do? Is this your priority? I have no doubt that just as we've seen since Athens 2,500 years ago, and every tribunal system we have had in this country, if this is done, it is done simply because, one, they have lax rules. The rules are not as strict as the normal courts. Two, they are prone to political manipulation and they will be politically manipulated. I don't think they are going to pick Kwarteng and put him there. All right? So see, we should appreciate the fact that if we want to build a country, we need to build it for everyone. Okay? Today, the opposition is on one side and they are saying, no, don't do it. I worry that if they do this, power changes hands. We have seen things that the opposition said we will abolish when we come. They come and they use it. Okay, let's build a country we will all be comfortable in. As for the speed of the justice system, from England to everywhere, when you are the accused and you are the one whose liberty is at stake, you appreciate the fact that it is useful for the wheels of justice to grind slowly. Nobody likes it. Okay, so please, we can do a lot to speed it up, but to speed it up does not mean take out certain parts, put people on a railroad and just move them in. Okay, so please, when we talk about, look, the people who have the power today, they will do what they want to do, but they must be minded. And just the way they have cited examples, I am telling you as a matter of fact, there's a history of tribunal. Check every one of them. The two things you will find is that their rules are more relaxed than the normal courts, and they are prone to political manipulation. And often that is what happens.
Would you not say that the framers of the Constitution were minded about some of these weaknesses you talk about? Reason why they put some of these provisions in there.
Good.
For instance, to check the appointment onto the panel and so on, the criteria, and also what is expected to be of high moral character, proven integrity. These are requirements for even appointment onto the Supreme Court, is it not?
Okay, good ideas don't implement themselves, and talk is cheap. When you say high moral character, who determines that? Okay, was King David a man with high moral integrity? King David, God himself said David is a man after my own heart. Was he a man of high moral integrity? The person God says is a man after my own heart. Was he? Who is the mother of Solomon? Okay, so you can say some of these things. That's number one. Number two, again, some history. History is this. Do you know the people who sat in the Consultative Assembly and passed the 1992 Constitution? Do you know that the lawyers boycotted it? Are you aware? Mm-hmm. The PNDC people who did tribunals, who later in their transitional provisions annulled it, okay, sat down and wrote this constitution, and the lawyers boycotted it. So they put their things inside, all right? And I've told you that not one, but two review commissions have sat down, take a look at this, look at our history, and concluded that let us not do this. Okay. In the Bible, it says all things are permitted, but not all things are useful. It is a bad argument to say it is in the Constitution, so let's do it. Okay. Learn from your history. Otherwise, you are bound to repeat its mistakes.
Yes. Now, Bernard Bill say, "Mbrano, say TV."
What's the need for the tribunals now?
So this is it. Let me also say, before I even come to this, look, Alfred, the behavior of our brothers on the other side is becoming, I don't want to use a certain, look, we sit in parliament as one body and we work together, both sides, regardless of your numbers. The Committee on Legal and Constitutional Matters is made up of both bodies, both parties. When this bill was introduced, it was referred to that committee made up of both. They went to sit together, work and produce this report as I have. There was no dissent. Let's stop this. There was no dissent from a member of the NPP. They were both together. Yes, this is the report level. I have. Anybody can read. Their behavior is becoming something else. You sat together and came by this. You are talking about day to day. It's been the proposal here because you don't have the final document. It's been I wouldn't say amended because it's been changed. And then the committee recommended that it should be expeditious. So we've taken it out. When the final document is out, you will see. So it's been taken care of.
So at the committee level, there was consensus.
This is what they brought. In fact, they raised their issues and they were all captured. And it has to do with the substance of and not as though we don't agree to the entire thing. Do you understand the point I'm making? Of course, at the committee level, you raise, this should be amended, let's do it this way. And it was all captured. And the thing came to the plenary and you are behaving as though you've never heard it. What sort of behavior is this? That is a hypocrisy I always talk about. You were part of this is the report. Anyone wants to read, this is it. And the bill. You did the work together and then you came and you said, we don't want it. What happened to the committee? Why didn't you raise it there? Why were you part and parcel of the process? Why didn't you work out then? And the things we are hearing, I'm a bit surprised. Look, see, they are talking up. So as for the fear, it's unfounded, completely unfounded. That's one. Now, look, and that is why I said, in fact, this thing about, even with the fear, Nana Addo Dankwa Akufo-Addo as Attorney General at the time, in Sunyane, at the Bar Conference in 2001, talked about this tribunal. That's why he gave a clue that they will abolish it. He never cited, because it didn't exist, he never cited that so-called PNDC thing.
Okay, quickly.
I want you to strengthen the argument. You see, culturally, we have this, it's not just, and that's very serious. They tell you that when you cure a madman, there will always be the residue of madness that he can use to intimidate people. So when you say it's unfounded, it's too extreme. That one is there. When you cure a madman, there will always be a bit of the mad.
You see, the reason I'm saying this, so I've thrown a challenge that the PNDC one, for me, and as I have read about, it's not the same as what we have under 1992 Constitution. So if we are able to cite one case,
there are.
So between 92, between 92 And then 2000 and what do you call it?
This is over 10 in the law reports there are.
No, but beyond 92, of course, I'm saying that. But in our court, there are decisions that have always been over 10. I'm saying that the 92 one took care of the appellate procedure. So if a decision doesn't go your favor, just as we have the normal courts do, you appeal. But the appeals is as though during the PNDC era, you didn't even have that right to appeal through the normal courts. That has been taken care of by the Constitution. I'm saying that the safeguards are there in the Constitution. It is not as if somebody is now seeking to bring it up. So what am I saying? Look, the issue has been this. Delays. And we are talking, and like Nana Addo Dankwa Akufo-Addo as Attorney General, what I said, all he said was that it's expensive. He never made mention of PNDC thing because it didn't exist. In Sunyani, go and read the statement he put out there at the bar conference. You see, so the issue is about delays. And if anybody tells me that there will be power, there's nothing like power. Indeed, this tribunal is going to deal in criminal cases only. At least
cases
only criminal cases. So at least I don't want to call the normal courts because this is also part of, but those courts we refer to as normal courts would have the opportunity to deal with civil cases, if any. So it's been stated here the cases they will be dealing with, and those cases are, I mean, these are cases. We all talk about this galamsey thing, and we are saying that the courts, I mean, the tribunals should take care of them. What is the issue? Our courts, this galamsey thing, people go to court and it takes sometimes years. I've done cases, it takes years for us to even know the outcome. By which time, sometimes evidence, people may have been transferred, the authorities that got them arrested, witnesses and all that, would not even be there to testify. So we are saying, and as I said, it's in the report that instead of the day to day or a day after a day, we are saying that it should be expeditious, and that has been approved. So when the final document is there, because the committee was of the opinion that you cannot, that would be tying the hands of whoever. Allow, at least you use the word expeditious so that they will be guided. But it's not as though every day you have to. In fact, there is even the Saturday thing there. We've taken them out. It's not going to exist anymore.
I see.
So it's been taken care of. We are trying to bring up as many courts as possible. This one is why we were in this country. What led to the fast track high court? And somebody is saying that is the same high court. It's not. It's not. You established it. No, but this is also within the court structure according to the law. We are lawyers. According to the Constitution.
Why are you then creating the customary tribunals? The Constitution is also asking for 125.
No, the fact, and you see, you've even made a point. We know the justiciability of the directive principles of state policy. We've gone through this. We've gone through this as lawyers. We know. So
that's why it's 125, not.
You mentioned education and all that.
No,
it's
I'm
part of
125.
You just said it. You said something before. You said
respond to this 125 too.
That why are we able to implement everything in the Constitution within a day? Are we able to? The fact that we've not been able to implement one means we cannot implement another. No, please. Let's do what are they saying? What law has been breached? In all this, they should cite which law has been breached. You are only, and now I'm saying that there is no issue because they were part of this whole thing. It's only when they come out, the normal politics. They did it with the LGBTQ. If the report is here and they are listening or watching, they should tell me that they never participated in the work that eventually came to Parliament.
Yes. Now, you see, when I spoke to normally lawyers, I seek opinions on because I'm not a lawyer. It seems as if some people are for it, some people are against it. And I think that it's mostly coming from the viewpoint of the dark days, how some of these systems were manipulated. That's why the Supreme Court had issues with the fast track high court President Kufuor established. It seems as if the court system normally dislikes an introduction of something. They believe that the intent is mostly for political gains. So Kofi Bentil, political manipulation is based on the history of the tribunals. But when you also listen to Honorable Bernard Bedu Kinley, he talks about safeguards that now head out to you couldn't appeal. Yes, you could demand and answer your punishment where you can't appeal, but now you can appeal. Now, also one of the issues is the people who be appointed on the tribunal. We take Kofi Bentil, will be the Kwasi Kwarteng or NPP, NDC certainly will not, or the judiciary will not appoint someone like Kwasi Kwarteng to be there. But also, even the appointment, because I was arguing with Mame, if you say one sorry butcher, the Court of Appeal judge on the issue of Article 144 that one of the perceptions, because the Supreme Court event at Supreme Court at 150 years, that one of the perception about the Supreme Court is that judges appointed by regimes often are seen as a puppet of that regime. And also, one of, for example, President Mahama didn't call High Court 2013. President Kufuor didn't call Court of Appeal to Odias Money. It doesn't matter who appointed her. Because even say oh kasa yense appointment the board judges in this case the original tribunal, the Judicial Council that recommends judges. Mahama, a clear example. This week, President Mahama bought 3 judges this Munku Supreme Court. Do you know what happened? President Kufuor or nominated judges are NDC because of one shooting it down. 2 of the judges were there. The only difference is Anthony Forson, the former Bar Association president. The 2 no account. They were named by President Kufuor. President Mahama Baye, interestingly, so it tells you, so her point was that Eugene, it's not about the appointment, it's about the integrity of the person appointed. Because even the Judicial Council who does the recommendation, the nomination of the people in the Judicial Council are by the president. It will show the current makeup. Xavier Susuka Emadine employee NDC MP. Clare Kasati because independent person, but is appointed by the president. So he's saying that if it's just by mere saying that if you are appointed by somebody, it means that you are serving the person or the interest of the person. Even the people who recommend judges to be promoted, even the people who make the judges write the exams, even the people who sit on the Judicial Council to review the portfolios and CVs of the judges and recommend them to serve on higher court and all that, are appointed by the president. So I think that for me, they passed it. They have the numbers to pass it. Preliminarily, judges now, I'm confused as they are confused. So you can only see what will happen. But the only thing I'm happy about, as someone who always advocate for justice, is that there's appellate processes introduced. I can go to a higher court and seek remedies there. I think that for me, that is the only thing I'm happy about. That there are appellate processes. And even when the tribunal, you feel that it has been manipulated, there's been a kangaroo court or whatever, you can go to a higher body to talk about it. This is Mimi view. We ain't a lawyer for. To your lawyer, and so a critical analyst, certainly bring that comment in the comments. I said, no, because me will be 50 cedis for the match, no more 3rd place, France and England. No, Obienya, me money in Obienya. Koye 6-4. But if you have maybe better comments on her ball, but also the comment, but one or two, no for enya. But I all bent in me the man. And I'm cultural say on send them in a number and still on find a number no MI. It's Mr. People who video ya ko Facebook you just to verify. Go ja number no message this can amount. No be the other some the amount. You know no be the chair me busy bedi. Into me that say the video will be the producer especially as time goes on be hu ni back. So make sure some subscriber most subscriber no click the notification the video be tuma. We be hu no et ma you certainly have a comment. Feel free leave that comment in the comment section. Make sure so be sure see the amount me here Ghana so here. Bye-bye.